Okay, this is file 24-22060-FH, People versus Jennifer Marie Berger. We are here today for a pretrial conference in this case, and we are proceeding by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure for the people.
B.B. McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Ms. Berger. I'm appearing in lieu of and on behalf of Mr. Malaro, who's the assigned attorney for this case.
Okay, and where do we stand, Mr. Murphy, with Ms. Berger's case today?
Your Honor, we're going to ask if we could set another pretrial on this matter for whatever fits the court's schedule best, as long as there's no objection by the prosecution.
Ms. McClure.
I believe this is the first pretrial, so I have no objection.
Okay, and I apologize, I forgot to bring my dates with me. Yeah, if you don't mind. If you give me just a moment, Kelly's being good enough to get those for me, so I'll have that for you in a second.
Thank you, Your Honor.
Okay, I can do February 5th at 8:15 a.m.
Yes, Your Honor. My office will prepare the stipulation order for that date and time.
Okay, anything else we need to address today?
Nothing from the defense, Your Honor. Thank you.
No, thank you.
Okay, Ms. Berger, you are all set. You can go ahead and log out then.
All right, thank you.
Thank you, Ms. Berger. Have a good day.
You too.
Okay, Mr. Mawad, I think we have Mr. Gargan with us now.
Okay.
So this is file 24-21979-FH, People versus Paul Anthony Gargan Jr. We are here today for a pretrial conference in that case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Your Honor, good morning. Elias Muad appearing on behalf of Mr. Gargan.
Okay, and Mr. Mawad, where do we stand with Mr. Gargan's case today?
Judge, Ms. McClure and I have been talking about restitution. He has a little over $21,000, and I just talked to Ms. McClure this morning. If you can give us anywhere between a 2 and 4 week adjournment, he's gonna pay that $21,000 to the victim in the case, but we're going to need a little instruction on how and who to give it to. Once he does that, I believe there'll be a plea at the next hearing, and then we'll worry about the remaining restitution at sentencing.
Okay, Ms. McClure, anything we need to address from the people's side?
No, I would agree with Mr. Mawad. My only preference would be a 2-week adjournment because I don't think it'll take that much time. And I would like to get that plea entered so that we have some time before sentencing, before kind of the deadline of when we would like to see this resolved.
I don't have a problem with that. That's fine.
Okay, we can do January 29th. That'd be 2 weeks from today at 8:50.
That's fine. That's fine, Judge.
Okay, Mr. Mawad, would you prepare that stipulation in order?
I will. And Phoebe, I can sign your name?
Yes.
Okay, great.
Is there anything else we need to address with the case today?
No, Your Honor.
No, thank you.
Okay, thank you then, Mr. Gargan. Your next date will be January 29th at 8:15 a.m. So you can go ahead and log out.
Thank you.
Ms. Underwood, are you ready to proceed with Mr. Moreno?
Could I have a brief breakout with him, Your Honor, please?
Yes, 1 second.
Thank you.
Mr. Murphy, I also have Ms. Betzer here. Are you going to need a breakout session with her?
Just briefly, please, Your Honor.
Okay. Mr. Moreno, if you give me a moment, I'm going to put you in a breakout session with Ms. Underwood.
Okay.
And Ms. Betzer, I'm going to place you in a breakout session with Mr. Murphy.
Okay.
The gentleman at the MDOC facility, can you tell me your name, please? The gentleman at the MDOC facility, can you hear me? All right, I'm having an issue. I don't know if you can hear me, sir, but I can't hear anything. It looks like you said something. I can't hear you.
Can you hear me now?
Yes, now I can hear you.
The mute button was on.
Okay, what's your name?
Heath Michael Hall.
Okay. Okay, Mr. Hall, your attorney is working with another client right now, so I'm going to put you back in the waiting room for a few minutes. As soon as she's available, I'll bring you back in and we'll get to your case.
Okay.
Okay, you're here for Carly Frank.
That's correct, Your Honor.
Is not logged in or here in person at the moment.
And Judge, just for judicial economy purposes, I've reached out to her about 15 times with no response, and I did express it to the prosecutor. I'm assuming they're going to be asking for a bench warrant if she does not show up today, but I've made a lot of efforts. The woman's just not contacted me back, Your Honor.
Okay. All right, I think we can go on the record with that one then. So, Mr. Carly Frank. This is file 23-21418-FH People versus Carly Frank. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B.B. McClure on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194 on behalf of Ms. Frank. Consent to appearing via Zoom, and thank you for allowing that option.
All right, and the record should reflect that this matter was set for a pretrial conference this morning at 8:15 a.m. It is now 8:26 a.m. Ms. Frank, well, I just had a new person pop into the Zoom waiting room, so let me see who that person is. Right, I have a new device in the Zoom session. The device is named Samsung SMA1 something. I'm going to send you a request to unmute. And can you tell me your name? The person that just joined the Zoom session, can you tell me your name?
Harley Frank.
Okay, so this is Ms. Frank. Mr. Amadeo, would you like a breakout session with her?
No, Your Honor, thank you. I'm going to request a 2-week adjournment and ask one more time that she contacts me. I don't want to take up your time. If she does not contact me, I'm going to ask to withdraw from the case. Carly, please contact me. If the judge is willing to give us a 2-week adjournment, we need to talk and get this done. That's all I'm asking for today, Judge. I don't want to take up your time with a breakout room.
All right, I will allow the 2-week adjournment at this point. So that'll be January 29th at 8:15 a.m. I apologize, Ms. McClure. Is there anything we need to address with the case from the people's side today?
No, Your Honor, thank you.
I will say this is quite an old case at this point. I know there have been substitution of attorney, which delayed things, but at this point, Ms. Frank, you need to contact your attorney and we need to move this case forward. I am going to set it for trial at the next pretrial conference. And there's just no, we're running out of what constitutes good cause at this point. And so that's going to be the court's process going forward. So January 29th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
All right. You can go ahead and log out then, Ms. Frank. Ms. Underwood, are you ready to proceed with Mr. Moreno? Ms. Underwood, are you ready to proceed with Mr.
Yeah,
Moreno?
Yes, we are, Your Honor. At this
All right,
time, Your Honor,
let me call the case.
thank you.
This is file 24-21714-FH, People versus Jesus Joseph Moreno. We are here today for a pretrial conference in the case, and we're proceeding by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Moreno this morning, Your Honor. Thank you.
All right, and where are we with Mr. Moreno's case, Ms. Underwood?
Your Honor, Mr. Moreno has made significant progress on paying down this child support. At this point, the prosecution has offered Mr. Moreno a delay plea, Your Honor, in that if he pleads guilty to count 1, failure to pay child support, a 4-year felony, the case would be placed on an 11-month delay, during which time, if Mr. Moreno pays it down to $20,500, I believe, Mr. Moreno would be entitled to an attempt, Your Honor. And should Mr. Moreno pay off the entire arrearage, he would be entitled to a 90-day disorderly, Your Honor. I believe Mr. Moreno wishes to avail himself of that plea offer today.
Okay, Ms. Brenner, is that a complete and accurate statement of the plea agreement?
Yes, Your Honor. So he'd be pleading guilty. We'd delay it 11 months, pay as ordered, down to $20,500 for an attempt, pay in full for the misdemeanor.
Okay. Mr. Moreno, would you raise your right hand, please?
Yes.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are Jesus Joseph Moreno, is that right?
Correct.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Correct.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Other than as we've discussed it on the record today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Brenner?
That's correct, Your Honor.
Ms. Underwood, is that also your understanding, Mr. Moreno?
I was under the advisement that she said something of the fact of 2 years. She didn't state no 4 years.
You would earn a reduction to the 2 years if you pay your balance down to 20,500. Do you need
So
more
what
time
you're
to talk to her?
What you're
No.
pleading to today has a maximum penalty of 4 years. If you get your arrearage paid down to the amount agreed upon, you would be allowed to plead to an attempt. And the maximum possible penalty for that would be 2 years.
Okay.
Okay, do you want to talk to Ms. Underwood any further?
No.
Do you want to proceed?
Yes.
Okay. If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. You also have the right to testify at your trial if you wanted to testify. You understand, Mr. Moreno, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about May 1st, 2018 through February 28, 2021 in the city of Adrian, County of Lenawee, that you did commit the offense of failing to pay child support?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not
Yes.
your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Moreno to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Moreno, other than as we've talked about it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, just on what you stated.
Okay. Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, do you want to cover the factual basis?
Thank you, Your Honor. Yes. Mr. Moreno, do you and did you have a case in the circuit court file number 2073109DS but where you were ordered to pay child support?
Yes.
And between the dates of May 1st, 2018 to February 28th, 2021, you did not pay your child support as ordered, correct?
Correct.
And you amassed an arrearage that as of 4/16/21 was $35,000 at that point, correct?
Correct.
And you know it's a crime not to pay child support.
Yes. It's also a crime for them not to let me see my daughter. That was the purpose of that.
But it's a crime not to pay child support, correct?
Yes, ma'am.
Thank you. I believe we've established the facts, Your Honor.
Ms. Brenner, are the people satisfied?
And sir, that order was in the state of Michigan and the county of Lenawee, city of Adrian. Is that correct? That child support
Yes.
order? Okay, people are satisfied. Thank you, Judge.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. Brenner?
Yes, Your Honor.
It has,
Yes,
Your
sir.
Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Moreno has had full knowledge of his rights, has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in it. So any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for, we need to go out 11 months.
Judge, did you want our office to handle this, or is this Mr. Coast? We weren't sure. This is a delay.
So we usually come back and put them on the delay. We get probation, do the report, then we come back and then we sentence them to the delay. Isn't that how we would normally do it?
Yes.
Judge Anslow does it to where I actually monitor the case to make sure that the requirements are done
Okay.
prior to the sentencing.
Okay. All right then. So what I will do is set sentencing for December 19th at 8:15 a.m. And Mr. Moreno, I'm going to put you in a breakout session with Mr. Coast so he can get your contact information.
Do we do the PSI or no? I'm still confused, sorry.
I think what would make sense is so I'd like to also, let me set it for a status conference on November 19th. That's a Wednesday morning at 8:15 a.m. Actually, no, let's go with November 12th, not the 19th. That'll give us one more week. And so if it works with probation, I'd like to have them hold off and not do any PSI. We'll check in at that status conference. If we need the PSI at that point, we'll have probation prepared. That way it would be more timely if we get to the sentencing date on December 19th.
Okay. And what was the November date, Judge? I'm sorry.
That was November 12th.
Okay.
All right. The only other thing is that the court had previously entered an order for fingerprints, and in checking the file yesterday, I still didn't see fingerprint information. So Mr. Moreno, you need to have your fingerprints done before the sentencing. If we get to the sentencing date and I don't have the fingerprint information in the file, we can't proceed with sentencing. And at that point, the court's going to have to do something in terms of making sure we get your fingerprints, and that's likely going to be taking you into custody to make sure that they get done. So you need to get those fingerprints done.
Can I go to a local here in Ohio? Sheriff's Department?
I doubt that they would do that for you. Who does them for the state police does them for your case? Is that correct, Ms. Brenner?
I believe so, yes, sir.
So you need to go to a state police post in Michigan.
All right.
All right, so I'm going to put you in a breakout session with Mr. Coast.
Thank you, Judge.
All right, Mr. Murphy, are you ready to proceed with Ms. Betzer?
Yes, Your Honor.
And Ms. Underwood, while we're doing that, I have Heath Hall in the waiting room. Do you need to speak to him?
I'm sorry, Your Honor.
Do you need to speak to Heath Hall?
I'm sorry. Something, I couldn't hear you.
Heath Hall.
Yes,
Do you need to speak to him?
we can proceed with him. It's a competency issue, Your Honor.
Okay, let me do Ms. Betzer's case first. This is file 24-22061-FH and 24-22062-FH. People versus Alexis Marie Betzer. We are here today for a pretrial conference in those cases, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayanetto?
Alex Bayanetto for the people.
Matthew Murphy, appearing on behalf of Ms. Betzer.
And Mr. Murphy, where do we stand with Ms. Betzer's cases today?
Your Honor, we're asking to adjourn for another pretrial on this matter. That's what Mr. Malaro had indicated. We're asking for that to occur unless there's an objection by the prosecution.
No objection, Your Honor.
Okay, anything else we need to address?
Not that I'm aware of from the defense, Your Honor.
Nothing from the people, Your Honor.
Okay, let's go with February 19th at 8:15 a.m.
Yes, Your Honor. My office will prepare the stipulation order for that date and time.
All right, so Ms. Betzer, your next date is February 19th at 8:15 a.m. You can log in using all the same Zoom information you used today.
Okay, thank you.
Thank you, Ms. Betzer. You have a good day.
So, am I good to log off Zoom?
Yes.
Okay.
Yes, you can go ahead and log out.
Hello?
Okay, 1 second, Mr. Hall. This is file 24-21859-FH, People versus Heath Michael Hall. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, map the people.
Cheers.
Rhonda Underwood on behalf of Mr. Hall.
All right, in this case, we did have a competency evaluation. The court has received
That's correct, Your Honor.
received the evaluation from the Michigan Department of Health and Human Services. Ms. Underwood, Ms. McClure, have you both received that?
I have received it, Your Honor, and reviewed it. According to Megan Rowland, licensed forensic psychologist, Mr. Hall is incompetent but restorable with treatment, Your Honor. We would ask the court to use that in their finding of competency today, and based on that, find Mr. Hall incompetent and order the Department of Corrections to submit him for treatment to allow his restoration to
I'm
competence.
already in treatment. I'm already in treatment, RTP, I'm in mental health already. Same place I've been 29 years, prison.
Okay, Ms. McClure, do people have any objection to the court using the Department of Health and Human Services Center for Forensic Psychiatry report dated December 19th, 2024, and authored by Megan Rowland for the purposes of making that determination?
No objection, Judge.
Do people have any other evidence they would like to submit on that issue?
No, Your Honor.
Ms. Underwood, does the defense have any other evidence that they'd like to submit on that issue?
No, Your Honor.
I do. I swung on that guy, he was keeping me up all night trying to flash in my eyes, but I'm not guilty. I never connected, I never punched him.
All right. So the court has received the Center for Forensic Psychiatry report as indicated. That report does find that Mr. Hall is currently incompetent to stand trial. However, he is likely to regain competence with treatment. And so based on that report, the court is going to find that Mr. Hall is incompetent to stand trial, but restorable. There is a substantial probability that Mr. Hall, if provided a course of treatment, will attain competence to stand trial within the time limit established by law. And so therefore I'm going to order that he undergo the appropriate treatment. I do have.
I'm taking this to trial all the way. I want to expose some crooked, corrupt people. I'm taking this all the way to trial. Believe that. If I didn't assault nobody, I didn't assault nobody. I'm not going to admit something I didn't do.
I do have an order to that effect, and I have signed it.
Thank you, Your Honor.
So we will proceed with the case then once Mr. Hall has been restored to competence.
Thank you.
Did the court set a review date or no?
I thank you for that. Let's set a.
Can I suggest 90 days out, Your Honor?
Thank you. We'll set that date for. Let's go with April 16th at 8:15.
Is a Zoom writ okay for that date?
Ms. Underwood, is Zoom writ all right?
I will.
Can we conduct that? Can we conduct that by Zoom, the review date?
Yeah, that's fine.
Okay, so a Zoom writ will be fine.
Thank you.
All right. Mr. Hall, you can let the officer with you know that you're done with court for today.
I'm done with y'all forever. That's how I'm throwing y'all like a fire in the end.
Okay, Ms. Underwood, Justin Shelton is here. Do you need a breakout room with Justin Shelton?
Yes, just briefly, Your Honor. Thank you.
All right, Mr. Shelton, I'm going to put you in a breakout session with Ms. Underwood if you give me just a moment.
Okay.
Okay, Mr. Dagger Margosian, Ms. Edwards is here in the courtroom. Are you going to need to speak to her?
Yes, please, Your Honor.
Okay. Let's see. Sierra, are you there?
Judge.
Could you turn on the iPad outside the courtroom for me?
Absolutely.
Thank you. So Ms. Edwards, if you want to step out to the hallway, someone will come out and get that iPad hooked up, and I'll have you speak to Mr. Daggerman. Okay, this is file 19-19673-FH People versus Justin Matthew Shelton. We are here today for a hearing on a probation violation, alleged probation violation. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda, I'll do it for Mr. Shelton this morning, Your Honor. Thank you.
All right, and it looks like this probation violation was related to payment of fines and costs. So Ms. Underwood, where do we stand with Mr. Shelton's case today?
Mr. Shelton was into probation yesterday and paid $1,400, Your Honor. I think all he owes is another $94. So I think we just have a very brief adjournment we need, Your Honor.
Okay, it sounds like that is appropriate, so I will adjourn this to Mr. Shelton, how long do you think you need to pay that $94?
Possibly, could you give me 2 weeks if possible?
Yeah, so what I'll do is we'll go to February 19th.
Okay.
No, I'm sorry, let's go with February 12th instead. So that's 4 weeks.
February 12th, okay.
So February 12th at 8:15 a.m.
Okay, sounds great.
You'll log in using all the same Zoom information that you used today.
Okay, Appreciate it.
All right, so you're all set. You can go ahead and log out.
All right.
Okay, let's see, Ms. Underwood, Mr. Bowker is not logged in. Have you heard anything from him? Oh, Ms. Underwood disappeared.
Your Honor, he's continuing to make payments. Miss Underwood and I discussed yesterday adjourning it out to give him additional time to make payments. I'm not sure why he's not here. I don't know if she's been able to get a hold of him or not.
Hey, Sarah.
All right, thank you. Okay, so Ms. Edwards, I'm going to put you in a breakout session with Mr. Dagger Margosian right now.
Okay.
All right, and so let me call Bowker next. So this file 24-21719-FH, People versus James Thomas Bowker. We are here today for a pretrial conference in this case and proceeding by video conference. First, I have the attorneys place their appearance on record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Bowker this morning, Your Honor.
And Mr. Bowker is not present here today. Ms. Underwood, have you spoken to him or have?
If I could just have a minute, Your Honor, I'd like to try to reach him. So if I could just have a minute. Thank you.
I guess Ms. Brenner had indicated that he's making payments and the plan was to adjourn. I guess I don't have any problem just adjourning it unless Ms. Brenner wants his appearance.
I'm okay with just adjourning it without his appearance this time, Judge. If he doesn't appear next time, I won't be agreeing to an extension, though.
Thank you.
Okay.
And we talked about 60. We talked about 60 days, right, Rhonda?
That's fine.
Yeah.
Okay, so we'll be looking middle of March. Let's go with March 19th at 8:15 a.m.
Thank you, Your Honor. Rhonda, I'll see you over at the other court.
I will do the stipend order with Ms. Brenner's permission.
Yes, you can sign it for me. Thank you.
Thank you. All right, and then Ron, I have Davey and Ryan here. Are you going to need to speak to him before we go on the record with this case?
Yes, I would like to speak.
Okay. All right, Mr. Ryan, I need you to unmute your device, and then I'm going to put you in a breakout session with Ms. Underwood.
Okay.
All right. Okay, and then we have, I should have Ms. Guessman here from the jail. All right, I have a jail device logged in. The camera is off. Oh, there we go. All right, are you Ms. Guessman?
Yes, sir.
Okay, and are we ready to go on the record?
Yes, you are.
Okay.
Yes, sir.
This is file 24-21976-FH, People versus Gianna Isabel Guessman. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, may I have the People.
Attorney Nancy Eaton Gordon on behalf of Ms. Guessman to Public Defender's Office conflict list.
Your Honor, Jen Glazier, I'm here
We had a conflict, so it got assigned out of our office, but I think the other co-defendants have been taken care of. And this is kind of a unique case, so I'm gonna help.
We're trying to get
try to get this thing worked out. It's a pretty complicated case.
All right. So where do we stand then with the case today?
Your Honor, we believe that we're going to try to enter a misdemeanor plea down in district court. I guess what we would ask to do, if Phoebe's all right with that, is remand it back. I would like to meet with Ms. Gessman next time in person, if they'll bring her into court. And we need to talk to the community mental health. It's a situation where she probably needs some community mental health services, but there's also a problem with, I don't know where she's gonna go once she's released. We need to see what type of housing they can figure. It's a, like I say, it's a fairly complicated case. I think it'd be easier, if you're all right with it, Phoebe, to remand it back to district court, and then I'll meet with her down there. And in the meantime, I'm going to talk to community mental health and whoever else might be able to help her with housing.
Your Honor, I would add, we did have it slated for a capacity exam as well. That has not been completed. My office has been following up, and as of, I think the last follow-up was about a week and a half ago, they still do not have a date on capacity. Criminal responsibility was determined months ago, but now I have concerns about that, but I'm hoping we can get those addressed, if we can get some services that maybe are not available for her.
I got it backwards. You got criminal responsibility, but not.
No. You got competency.
You got
Criminal
competency.
responsibility has been ordered but not assessed yet.
And if they found her competent, Your Honor, we may be able to take care of this downstairs without doing the criminal responsibility.
Okay, Ms. McClure.
Just as a background, which I think is important in making this determination, Ms. Gessman was pending for quite some time down in district court while she was receiving treatment to become competent. So she was initially incompetent but restorable. They were finally able to get her competent with her treatment and release her from the treatment facility that she was in. She did pretty good with that once she was initially released, and that's when we were able to get the case, excuse me, bound over, and continue or work towards a resolution, and that happened in October. But it was shortly after that that I believe she stopped following up on her treatment, and I think, I don't know if it was supervision she was getting or just being medicated to remain competent, but nevertheless, it seemed like she had stopped what she was ordered to do, and that's what's kind of caused her to miss court and stop checking in with CMH, and that's why she's back in jail now, Judge. The main goal here was to get her into mental health court because I think she needs that extra supervision, and so my plea was fashioned in a way that she could take advantage of that. It is for a 1-year misdemeanor with mental health court, but part of that plea was that if she did not complete mental health court, that the felony charges would be reinstated. So for those reasons, and I did speak with the mental health court coordinators, and they indicated they could facilitate that with a plea in circuit court. So because of that, I would ask that she remain in circuit court. We enter the plea if that's what she's going to do. And get her into mental health court and through CMH that way. And then if she again stops doing what she's supposed to be doing, then we would be back in circuit court on the felony charges and could continue with the criminal responsibility at that time if she if we get there, I guess.
Okay.
My only concern, Your Honor, and we can keep it up here, if you'd adjourn in a couple of weeks, I'd like to get this going as quickly as possible. One of our concerns is whether she's competent enough
Right
at
now.
this point to even enter a plea. And you know, my initial conversation with her was that she is not. And I guess we got to figure out what we're going to do if she's not competent now.
And in my ongoing conversations with her since she's been in the jail, she's been deteriorating. I have very severe concerns about her ability to enter a plea at this point.
Can I just say that I've been going to health court? I don't know why I say that I have been, but I really have to go to health court for them. I go to health court every 2 weeks to come to them. And I've signed in and everything. I went and I checked up and everything.
I can understand her, Your Honor. I'm sorry.
Okay, I'm sorry, the microphone at the jail there was not good. I wasn't able to understand what it was you said, Ms. Gessman.
I said if I'm allowed to speak, I go to the community mental health every 2 weeks and everything. I sign up and everything. And I've been going, so I don't know why you guys would think that I haven't been going unless it's because I've been in jail, but other than that, I really have.
Yeah,
I think
and I understand Mr. Glazer's needs for wanting to get this going, but I think it has gotten going. I mean, she's been to CMH, she's gotten treatment, she was in a treatment facility. So it's not like she's sitting there without resources. The process has started. So really, we're just kind of waiting for this plea to be entered so she can officially be a member or participant of that mental health court.
Okay, but the defense would like an opportunity to ensure that at this point she's competent to enter that, please.
Yes.
Fair statement.
Yes.
Yeah.
Oh, okay.
That's the
And
concern.
you don't have any objection to keeping it here in circuit court? Will that
No,
happen?
if
Because
that'll help facilitate it, get it through. No, I don't have any objection to
At this
that.
point, I don't know.
We need to see her first, talk to
Yeah,
her.
that's fine. So at this point, what I'll do is adjourn it and keep it here. Just to, I don't, we didn't talk about a basis for the remand, and I don't want to try to remand it and have it.
Yeah, that's fine, Your Honor. If we don't need to get into it, that's fine.
That, so,
I do think there needs to be a basis to sign a new order for competency as she's already been evaluated. And I don't think the forensic center will see her without that.
I don't understand the defense be asking for that right now.
At this point, we want to talk to a person.
So
It's been
2 weeks from today is going to be the 29th
in January.
of January.
And the court will see that she's over here in person.
And you want her here in person?
Yes.
Yeah, we'll talk. I'll talk to her.
Okay.
Would that be at 8:15, Your Honor?
That will be 8:15, correct?
So the 29th, I apologize. Is that what it was?
Correct. Okay, is there anything else we need to address today?
No, Your Honor. I don't think there is. Phoebe, if there's anything from people.
Anything else, Ms. McClure?
No, thank you.
Okay. Ms. Gessman, you can let the officer that's with you know that you're done with court for today.
Thank you, Ms. Clover.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Mr. Dagner Margosian, are you ready to proceed with Ms. Edwards?
Yes, Your Honor.
Okay, Ms. Edwards, you want to come forward to the podium, please? Okay. We are on the record in file 24-21766-FH and 25-22100-FH. People versus Katrina Pearl Edwards. We are here today for a pretrial in the 24 case and arraignment in the 25 case. We are proceeding today by video conference and in person. First name of the attorneys place their appearance on the record, beginning with Ms. McClure.
A.B. McClure, on behalf of the people.
Your Honor, Michael Dagger Margosian for Miss Edwards.
And Ms. Edwards is here in the courtroom in person. Ms. You are Katrina Pearl Edwards, correct?
Yes, I am.
Okay. Mr. Dagger Margosian, with respect to the 25-22100-FH case, does Ms. Edwards wish to have that information read?
No, Your Honor, we'll waive formal reading. Stand muted at this time.
So court will enter a not guilty plea in the 25 case. So where are we with respect to the other cases, and where are we going next, Mr. Dagger Margosian?
Your Honor, on both of these cases, I'm asking the court for to adjourn them. I've been speaking with Mr. Hartung. He is on the 101 case, and I think with a little bit of time, we'll be able to resolve both of these. And so I'm just asking the court to adjourn this for approximately 60 days.
All right, Ms. McClure, anything to address from the people's side?
No, I would agree.
Okay, so 60 days is going to be about the middle of March. Let's go with March 19th at 8:15 a.m. if that date works.
Fine with me, Your Honor.
So March 19th at 8:15 a.m. Ms. Edwards, that will be your next court date. So you either need to be here in person as you are today, or you can log in by Zoom, and the bailiff should have our Zoom information if you want to do it that way.
Okay.
Okay. So you're all set.
Thank you.
Oh, I'm sorry, Mr. Dagger Margosian, would you do the stipulation in order for the 24 case?
Yes, I will.
Okay, thank you.
Thank you.
Okay, I have a device logged in as Jail Zoom 2. That device is muted and has the video turned off. I'm going to send a request to start the video. Call for stop. Okay, Ms. Underwood, are you ready to proceed with Mr. Dillard? He is not here today.
Hi, it's Caroline Judges. Victoria of the Heart and Road of Judgments.
Ms. Underwood, are you there?
Thank you. Bye.
Yes. I'm sorry, Your Honor. Could I just have another very brief conversation with Mr. Ryan?
Yes. Okay, and Mr. Fry, are you going to need a breakout session with Mr. Conway?
No, Your Honor.
All right, then we are on the record in file 25-22102-FH, People versus Ernest Lee Conway. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
E.B. McClure, map the people.
Brian Fry on behalf of Ernest Conway.
All right, and Mr. Conway is present from the Lenawee County Jail. Sir, you are Ernest Lee Conway?
Yes, I am, Your Honor.
All right, Mr. Fry, does Mr. Conway wish to have the information read today?
No, Your Honor, we would waive the reading and ask the court to enter not guilty plea and schedule this for pretrial.
All right, I will enter not guilty plea for Mr. Conway, and we can set a pretrial for February 5th, if that date works.
That works for me, Your Honor.
So February 5th at 8:15. Anything else we need to address today?
Your Honor, if the court will allow, Mr. Conway has asked me to address bond.
Okay, go ahead.
So, Your Honor, we had a preliminary examination in this case, district court, where one of the counts was dismissed or not bound over. He was only bound over on one of the two, and I don't think bond was ever readdressed after that. So the bond, as it's currently set, was for 2 felony charges, and there's only one at this point. Again, it's never been addressed since one was dismissed. Further, at the preliminary examination, there was no complaining witness. The prosecutor, from my understanding, has not been able to locate any complaining witness, and he was bound over solely on hearsay testimony from the officer that would not be admissible at an actual trial, but is at the preliminary examination. I know the judge actually noted when she bound Mr. Conway over that she doubted the evidence would be enough to actually convict him with a jury, but it was enough for the lower standard at a preliminary examination. So, you know, the likelihood of conviction in this case is very low. Again, there's no witness that actually says he did these things at this point in time. So we asked the court to take that into account. Mr. Conway does live in Adrian. He is a local recording artist who, you know, has music that's played on the radio. He has a social media following with, you know, tens of thousands of views of some of his music. You know, so we would ask the court to take that into account, that he would show up to court if he was granted a lower bond or PR bond in this case. So we would ask that the court to consider that. Thank you.
Ms. McClure, do people have any response?
Yes, Your Honor. This is Mr. Sneed's case, but I'm relatively familiar with the issues in the case and what happened in the lower court. The second charge in this case was not bound over on a technicality, just because the charge that was on the complaint was for the next step up, witness intimidation. It was, instead of a 4-year or less charge, and I might be getting the time wrong, but essentially it was the next step up rather than the next step down. So it should have been the 4-year witness intimidation. And I do know it's Mr. Sneed's intention to file a get key motion to add that charge. It actually was the duty of the lower court to add it upon bind over, and they failed to do so. But it is a good standing law that they should have added that charge upon bind over. When asked to do so to follow the law, the district court judge said we can address it at a different time, whatever that means. But essentially, Mr. Sneed will be able to file that get key motion and add that charge on. In addition, it obviously is a witness intimidation charge, which is why the complaining witness did not show up. Our office was able to get in contact with her after the exam to talk to her about that. So we do believe she'll be cooperative going forward, which given the likelihood of conviction then would be stronger in this case. And again, it's a witness intimidation charge for a reason. In addition, this is a habitual fourth offender and he has a pending absconding charge. So we would just ask that bond either remain or be increased in this case and not be lowered at this time.
All right, there's obviously differences in the parties' positions in terms of argument as opposed with regard to the issue of the witness and whether or not that witness will appear. I guess what concerns me most is that there's a pending absconding charge that Mr. Conway has that obviously speaks to whether or not he's likely to appear for his court hearings. I at this point, I'm going to deny the request to modify bond. I think under all the circumstances, as I've heard them today, it appears to be appropriate. So I'm going to deny that request.
Thank you.
All right, Mr. Conway, you can let the officer with you know that you are done with court for today.
When is my next court date? And Your Honor, my absconding, failure to appear in court is only on arraignment. A court date to pay some fines or whatever. It's not a failure to appear. I never failed to appear on a court case, and that was, and I only failed to appear on that because I had changed addresses, but it wasn't a criminal court case that I did not never appear to.
Mr. Conway.
All right, so Mr. Conway, if you can speak to your attorney about it. If you want to have a more developed hearing to provide the court with evidence about some of these issues, you can, but I have to make a decision based on what's been placed in front of me today, and I've made that decision. And so your next court date, I believe I said, was February 5th.
That's pre-trial?
That is a pre-trial, correct.
Okay, the victim has to be there February 5th?
You'll need to discuss that with your attorney. You can let the officer with you know that you're done with court.
Can I have a breakout room with my attorney before I leave?
I'll come visit you in jail, Mr. Conway. Thank you, Your Honor.
Mr. Fry, you said that. When you coming to visit me?
Probably Friday.
All right, thank you.
Thank you.
Okay, Ms. Underwood, are you ready to proceed with Mr. Ryan?
Yes, Your Honor.
This is file 24-21881-FH People versus Davian Scott Ryan. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B.B. McClure, behalf of the people.
Rhonda, I'll do it on behalf of Mr. Ryan.
Okay, and we do have Mr. Ryan here by Zoom. Sir, you're Davian Scott Ryan?
Yes.
Ms. Underwood, where do we stand with Mr. Ryan's case today?
The plea offer on this case, Your Honor, is that Mr. Ryan would plead guilty to fleeing and eluding 4th degree, and the fleeing and eluding 2-year felony, and the fleeing and eluding 3rd degree 5-year felony would be dismissed. I believe Mr. Ryan wishes to take that offer. I think we're probably going to need an amended complaint.
Okay, Ms. McClure, is that complete an accurate statement of the plea offer?
It is, Your Honor, and I do have a plea agreement form that was emailed to Miss Underwood back in October. I don't know if that's been referred to the court.
But I believe we would still need an amended complaint.
It is. I'm just making sure the plea agreement form was signed and returned to the court.
I will.
I don't have that.
Okay, I will. If I could have a brief breakout with Mr. Ryan.
Yes.
Are you able to, you're able to see me, right?
Yes.
Then if I could have a brief breakout just to show him the form, Your Honor.
Okay. Ms. McClure, is the amended information something you're able to prepare today?
Yes, I'm doing it right now.
Okay.
Should just take a moment.
Okay, I will restart that breakout session.
Or if the court would allow us, Your Honor, one brief adjournment, we could get all this done. I have, I know Mr. Ryan has another case down in district court that he actually wanted to have concluded before this case. So if we could do that rather than take the plea today, I know the court does not want to grant an adjournment unnecessarily, but perhaps that would, for time purposes, be better for us all.
I already have the amended information done, and I do know that the court's given quite a few adjournments on this, and the case in district court is not related to this case.
Is there any reason we can't go forward with the plea today?
Thank you, Your Honor.
Mr. Murphy, do you need a breakout session with Ms. DeHart?
I do not, Your Honor.
This is file 25-22096-FH and 25-22097-FH, People versus Victoria Marie DeHart. We are here today for an arraignment in both of those cases, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, may I have the people?
Matthew Murphy, appearing on behalf of Ms. DeHart.
And Ms. DeHart is present by Zoom from the Lenawee County Jail. Ms., you are Victoria Marie DeHart?
Yes, Your Honor.
All right, and this is an arraignment, so Mr. Murphy, does Ms. DeHart wish to have the informations read today?
No, Your Honor, we acknowledge receipt of the informations in both files and the witness list and the discovery demands in both files from the prosecution. We would ask the court to enter and continue a not guilty plea and just set a pretrial in this matter.
Okay, I'll enter a not guilty plea on both files and set a pretrial conference for, how about February 12th at 8:15?
Yes, Your Honor.
Is there anything else that we need to address today?
Not that I'm aware of from the defense, Your Honor, no.
No, thank you.
All right, so Ms. DeHart, you're all set. You can let the officer with you know that you're done with court for today.
Thank you, Your Honor. Have a good day.
Thank you, Mr. Hart. Have a good day.
Thank you.
All set.
I'm all set. Thank you.
Okay.
Mr. Murphy, oh. Mr. Murphy, I do not have Mr. Dillenbeck here. I don't know if you want to try to contact him.
Yes, Your Honor. Thank you for letting me know.
All right, Ms. Underwood, are we ready to proceed with Mr. Ryan?
Yes, Your Honor.
All right, Mr. Ryan, I'm going to send a request to turn your video on and then raise your right hand.
My video will not, it won't allow me to turn it on.
All right, then we raise your right hand and let me know that you have it raised, please.
My right hand is raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Davian Scott Ryan?
Yes, Your Honor.
You've heard the statement of your attorney and the prosecuting attorney, Mr. Ryan. Is it your intention to plead guilty today to count 2 on the amended information, 4th degree fleeing a police officer?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $500 fine?
Yes, Your Honor.
You also understand that it requires the Secretary of State to suspend your license for 1 year.
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Ms. McClure?
It is.
Is that also your understanding, Mr. Ryan?
Yes, Your Honor.
Guilty plea is accepted. There'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Ryan, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about December 18, 2023, in the city of Adrian, County of Lenawee, that you did commit the offense of 4th degree fleeing a police officer?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Ryan to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Ryan, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Ms. Underwood, do you want to cover the factual basis?
Thank you. Mr. Ryan, let me take you back to December 18th, 2023. Were you in the city of Adrian, County of Lenawee, State of Michigan?
Yes.
And at that time, you were in your car, correct?
Yes.
And you were the driver of that vehicle, correct?
Correct.
And you were given a visual or audible signal by Blake Hopprecht, a police officer who was in uniform and whose vehicle was identified as an official police vehicle, correct?
Correct.
And he was acting in the lawful performance of his duty.
Yes.
And he directed you to stop.
Yes.
How did he signal that?
With his lights.
Okay. And you did not, you failed to obey that direction.
Yes.
And in doing so, did you increase your speed?
I did.
And you know that's a violation of the law, correct?
Correct.
I believe the facts have been established, Your Honor.
Satisfied, Judge.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Ms. Underwood?
It has.
I will accept the plea that it's been given understandably, voluntarily, and accurately. Mr. Ryan has had full knowledge of his rights. He's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 14th at 8:15 a.m.
Okay.
Mr. Ryan from the probation department is going to be in touch with you to do a pre-sentence investigation. When you do that interview, please be truthful about this offense and about your background.
Okay.
I'm going to put you in a breakout session right now with Ms. Walsh from the probation department so she can collect your contact information, give you some instructions on what you need to do next.
All right.
I'm sorry, Judge. What was the sentence date?
February 14th.
Thank you.
Okay, Ms. Underwood, we have, you have Mr. Dillard, who is not present.
Okay.
So this is file 24-21905-FH, People versus Zachary Ryan Dillard. We are here today for a hearing on a summons for probation violation. We are proceeding today by video conference. The courtroom is also open to the public. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Dillard, Your Honor. But I believe this is a show cause, isn't it? So I'm not sure I'm appointed yet.
Oh, yeah. You know what? It is. So you had represented Mr. Dillard on some other things in this file, but this is a new show cause for probation violation. So the record should reflect this was set for a hearing this morning at 8:15 a.m. Mr. Dillard was ordered to appear. It is 9:40 a.m. and Mr. Dillard has not appeared either by being present in the courtroom in person or by logging into the Zoom session. I would also note that he did have a bond violation hearing scheduled last week that he did not appear for either. So the court is going to issue a bench warrant for his arrest and set bond on that bench warrant in the amount of $25,000 cash or surety.
What about Ms. Orozco, Your Honor?
Let's see. So that one, we don't have a proof of service showing that the order to show cause was served on Ms. Orozco. Oh, I'm sorry. Let me just make sure of that. All right. So this file 24-51638-PH, Caitlin Elizabeth Lorishon versus Maria Deanna Orozco. We are scheduled today for a hearing on an order to show cause for violating a personal protection order. The court entered that order on December 26th. There does not appear to be any proof of service in the file showing that that order was served on Ms. Orozco. I have reviewed both the paper file and the register of actions available on the computer. Neither of them reflect a proof of service. I would also note that Ms. Lorishon is not present here today, either by Zoom or by being here in person. And therefore, I am going to dismiss the order to show cause.
Thank you, Your Honor.
Okay.
I think that concludes my docket with you this morning.
Yes.
Thank you.
And then Mr. Murphy, are you ready to proceed with Mr. Dillenbeck?
Yes, Your Honor.
This is file 24-22094-FH and 24-22095-FH, People versus Ryan James Dillenbeck. We are here today for an arraignment in both of those files, and we are proceeding today by video conference. The courtroom is also open to the public. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure, map for people.
Matthew Murphy, appearing on behalf of Mr. Dillenbeck.
The record should reflect this matter was set for arraignment this morning at 8:15 a.m. It's now 9:44 a.m. Mr. Dillenbeck is not present in the courtroom. He is not logged into the Zoom session, nor has he been at any point this morning. Mr. Murphy, is there anything you'd like to say with respect to Mr. Dillenbeck at this point?
Your Honor, I believe last court date that we had, Mr. Dillenbeck's sister had contacted us to say that he was in Hickman Hospital. I don't see that we've had any contact from Mr. Dillenbeck since then. The number that we have on file, unfortunately, I was trying to call this morning, is coming back as unavailable to reach at this time. So I do apologize, Your Honor, but I don't know where he's at this time.
All right, Ms. McClure, would people like to say anything about that issue?
Just that without proof of him being at the hospital, I would just ask for a bench warrant with a 48-hour hold.
Okay. All right, so there are no prior failures to appear. So what I will do is I will wait the 48-hour grace period. If we don't hear anything about Mr. Dillenbeck in the next 48 hours, the court would issue a bench warrant for him. Mr. Murphy, obviously, if you're able to reach out and confirm that he's still in the hospital, let us know that, and we'll proceed accordingly.
Yes, Your Honor.
But if we don't hear anything, I am going to issue that bench warrant.
Yes, Your Honor. Thank you.
Yeah, I would set bond on the bench warrant in the amount of $10,000 cash or surety in each file.
Yes, Your Honor.
Okay, anything else we need to address with that case?
Nothing further from the defense, Your Honor. Thank you.
No, thank you.
Okay. All right, thank you then, Mr. Murphy. I think that's everything I had for you today.
Yes, Your Honor. That's all that I had down as well. Everyone have a good day. Thank you.
And the only one I had left was James Duff, but I haven't seen Mr. Daly. Do you know anything about that, Ms. McClure?
Yes, it looks like a noli pros was filed on that yesterday.
Oh, okay.
So, Judge, I know, or at least I believe that's the end of your docket. I have a short request to make, though, if you
Okay.
are free. Mr. Castleberry and I were supposed to have a bench conference with you tomorrow, and something came up for me personally, and I don't think I'll be in the office tomorrow, and he's in the building this morning. We were wondering if you'd have a 5-minute bench conference with us this morning.
Oh, sure. Yeah, if you want to come up, that's fine.
Okay, let me see if he's available right now. He said he's available. He's in the building until noon, so I'll see if he's free now. I know he was in district court and probate court. But if you'll just be in your office, then we can just pop up if that's okay.
Yeah, I should be available whenever works for you guys.
Okay. All right. I will get with him then and we'll pop up.
Thank you.
Thank
Judge,
you.
I was supposed to cover for Mr. Shelton. What did we do that?
Yes, we adjourned him. He paid
$1,400
paid himself down to like $94. So I adjourned him for 4 weeks.
Okay,
So
good.
February 12th is his next date.
2/12. Okay, great. And everything else is done. Okay, thank you.
Okay, have a nice day.
You too.